Thank you. I will take appearances.
Good afternoon, Your Honor. Shivesh Kuksal, I am self-represented.
Thank you, Mr. Kuksal.
May it please the court, Your Honor. My name is Mr. Hogan. I appear for the Legal Services Board, the third defendant in this proceeding.
Thank you, Mr. Hogan.
May it please the court, Your Honor. I appear for the first defendant in this proceeding.
Thank you, Mr. Imri. I understand there's a summons been issued in this proceeding. I have 3 proceedings this afternoon involving you, Mr. Kuksal. I will hear from you, Mr. Imri.
Thank you, Your Honor. Your Honor, can I just raise a housekeeping matter at the outset?
Yes.
Which is just that I have a commitment today. That in order to make that commitment I would need to leave by 4 p.m.
Yes.
And I understand the court doesn't sit for my convenience, but if it's likely that we're going to go past 4 p.m., I will just need to make some sort of arrangement. So I just wanted to raise that at the onset.
Thank you for letting me know, Mr. Imri. And are you appearing in all 3 proceedings this afternoon?
Yes, I am.
All right. Well, I think it is in everyone's interests. They are only directions.
Well, that's right. But often Mr. Kuksal's matters go a little longer than expected.
Yes, all right. Well, we will make accommodations where we need to. Just let my associate know if I'm not mindful of the time when we need to do that.
Thank you, Your Honor. With respect to this matter, there was a timetable proposed by our learned friend for the other defendants.
Yes.
For some interlocutory steps for the matter to be set down for the summonses that both defendants, or sets of defendants if you like, have put on.
Yes.
And our position is to consent to or agree with the timetable that was proposed by our learned friends.
Yes. So these are the proposed orders sent today.
The proposed orders that were sent today, I think, is in a different matter. Is that right?
Oh, I see. I have 3 that I received today, but I don't know whether...
Your Honor, we haven't...
All right. Mr. Kuksal, I didn't ask to hear from you yet. Mr. Imri is on his feet.
I think they might have been sent through yesterday.
All right.
So there were proposed orders provided by the Legal Services Board with respect to 2 of the matters, and then we sent through proposed orders with the third matter, the one that Your Honor was proposing to call last today, which is a proceeding to which they're not a party.
Yes.
And essentially the orders that we proposed in that matter essentially duplicate the orders that the Legal Services Board put on in the other 2 matters, so that all 3 proceedings would proceed in a like manner with a similar timetable, and then presumably be listed for hearing, hopefully collectively.
All right. So just let me open those. And Mr. Kuksal's received a copy of those proposed orders?
No, we haven't, and I'd like to be heard about that.
Well, hang on, I'm not asking to hear from you yet.
Unless he's giving evidence.
Mr. Kuksal, I'm going to let you know now that when another party is on their feet, it is not appropriate for you to interrupt.
I'm raising objections.
Please sit down. You don't get to raise objections when I've asked a question of Mr. Imri.
I'm objecting to Your Honor asking that question.
You don't get to object to my questions, Mr. Kuksal. It's not helpful.
Your Honor, you should hear me first before determining the appropriateness of the objection.
Please sit down, Mr. Kuksal. Mr. Imri, were the proposed orders provided to Mr. Kuksal?
I'll confirm that with my instructors, but in the ordinary course, of course they would have been sent by email to all the parties, but I can confirm that that was certainly the case.
All right.
Your Honor, when I said earlier that the orders replicated in that third proceeding, there is one difference, and that is because there has been no summons filed in that proceeding.
Yes.
Again, Your Honor, I object. That's a factual assertion, which is incorrect, and it's made from the bar table.
Please continue, Mr. Imri.
Yes. Your Honor, I'm making submissions about procedural steps that have or have not been taken in the proceedings, so that Your Honor has an understanding of where things are at for the purposes.
Thank you.
The summonses were filed in 2022, and they're pending for determination.
Please continue, Mr. Imri.
So to be clear, there's 2 proceedings in which summonses have been filed for summary dismissal and similar consequential orders.
And those are the proceedings. One of them is ending in 4808, and the other one is 00183.
That's correct, Your Honor.
Thank you.
And then the second proceeding, or the third proceeding if you like, which ends in 07, is the one to which my learned friend's clients are not a party, which is connected with the first one. That ends in 08.
0183.
08.
08.
Those 2 both arise out of the same criminal proceeding, which is no longer extant, but they are connected in that way. There has not been a summons filed in that proceeding.
Yes, that's right.
And so the orders that we are proposing in that proceeding provide for an application to be made, and then otherwise the timetabling orders to be the same.
All right. And so with those the proposed timetable, working from 0183, Could you tell the court what you are seeking?
Yes. Well, would it be more convenient to deal with 183?
Yes.
It's...
Sorry, Your Honor. I thought the matter that was called was 08, and your associate had said that the matters were being called separately.
Please sit down, Mr. Kuksal.
Sorry, Your Honor. I thought the matter that was called was 08, and your associate had said that the matters were being called separately.
We're hearing the first one at the present time, which is the matter,
Which is the one ending in 08?
which was 0183 was the matter called, I believe. Am I correct about that?
Not what we were told by your associate.
In any event, what Mr. Imrie has just told the court is that the 3 sets of proposed orders are somewhat similar for all 3 proceedings.
Yep, I just want the record of the proceeding to reflect what has been called. So are we dealing with 0183 first?
I think the matter that was called was 04808.
Is that right?
Yes.
Is that correct?
Yes.
Thank you. Thank you for clarifying, Mr. Imrie.
I clarified that, Your Honor.
In any event, the timetable that I'm about to address Your Honor about is the same as the 00183, in any event. So it is a distinction without a difference in that respect. So what's being proposed is the defendants to file and serve written submissions in support of their application by 4 p.m. on Friday the 4th of July, for the plaintiffs to file and serve written submissions in response, and any affidavit evidence on which they rely by the 25th of July, 4 p.m. on the 25th of July, and then reply submissions on the 8th of August, with the matter to be set down for hearing on a date not before Monday, the 11th of August. And the orders that have been proposed all have page limits attached to them, so I'm summarizing the timetable for Your Honor, but there is a little bit more to the actual substance of the orders.
Thank you.
And so that's what's proposed for 04808. That's what's proposed for 00183, and the only difference with respect to 05407 is that on that same date, same initial date, when submissions are proposed to be filed, where applications are already on foot, there would be an application filed on that same date, the affidavit, and the submissions filed together.
All right. Thank you, Mr. Imrie. I take it that Mr. Hogan, you concur with the timetable insofar as they...
Yes,
All right.
I absolutely do, Your Honor. Thank you.
Thank you. Mr. Kuksal, have you received a copy?
No, Your Honor. And I note that Rule 46.05 of the Supreme Court, General Civil Procedure, Rules, requires the service of any material in support of the summons to be made by 2 p.m. I believe it's a day prior to the day of the hearing, and the rules do not permit Your Honor to waive that requirement. So as far as we're concerned, no documents have been appropriately served. I was in a hearing this morning, as I had notified the court, and right after the hearing, I had to make preparations and make my way here. So I haven't checked my emails at all today, and that is why the rules require for adequate notice. But before I make any...
Mr. Kuksal, you do realize this isn't a final hearing, don't you? This is a directions hearing.
That's right. But the summons. The rules apply to summons for directions as well, and they specifically clarify that judicial registrars may not provide waiver from compliance with the rules. So Rule 46.05 of the General Civil Procedure Rules requires service of summons and supporting material by a certain deadline. It's 2 p.m., the preceding day. Nobody has filed documents in compliance with that, as far as we're aware. But before that, I want to raise the matter of Your Honor's recusal that I wish to make. I wish to make an application on behalf of the plaintiffs for Your Honor's recusal, and I'll quickly summarize the grounds upon which we rely, before addressing the court about the orders that we propose should be made. So the application is made on the basis of an apprehension of bias, and on the basis of Your Honor, the application to clarify, is made in respect of all 3 proceedings. And I would seek Your Honor's leave for the submissions that I'm making to be considered to have been made in all 3 proceedings, so I don't have to repeat application.
Yes. Thank you, Mr. Kuksal.
Okay. So, Your Honor, the application is made on the basis of an apprehension of bias and on the basis of the plaintiff's contention that Your Honor has failed to consider the effect of Your Honor's decisions on the human rights of the plaintiffs, in breach of the relevant provisions of the Charter of Human Rights and Responsibilities. And we rely on QYFM. I'm just bringing up the citation, Your Honor. QYFM v. Minister for Immigration, Citizenship, Migrant Services, and Multicultural Affairs, 2023, HCA 15, on the judgment of Chief Justice Kiefel and Justice Gagler. On the 18th of March, the controversy that arose was in relation to whether or not the orders that the plaintiffs were seeking to reinstate the proceeding were orders that the court could make on the basis that the defendants in the proceeding were aware of the underlying matters on which the plaintiffs had relied, primarily the fact that the criminal proceedings in the magistrate's court had come to an end. The plaintiffs provided evidence to the court of the defendant's constructive knowledge of the termination of the proceedings. The plaintiffs also referred Your Honor to the judgment of Justice Janane in which His Honor had acknowledged receipt of the information. The plaintiffs also relied on the principle of recognition of the judgments of the court by all other courts, which has a statutory basis in the recognition. There's legislation that I had referred to on the day. State and Territorial Laws and Records Recognition Act, 1928, that's the Commonwealth legislation. There's a Victorian equivalent of it as well. But, essentially, the legislation requires all courts and government officers throughout the country to recognize the orders and instruments properly issued by courts and other government officers of the Commonwealth, and of each state. So on the day, Your Honor agreed to not immediately reinstate the proceeding on the basis that and because Your Honor has not given reasons, I am inferring things based on what Your Honor had said. So the brief reason that Your Honor had given on the day was that Your Honor could not foresee any prejudice arising from the period that the defendants were seeking for the service of documents which they, improperly or dishonestly alleged had not been served. The plaintiffs had demonstrated to the court that those documents have been served on the defendants because the documents have been referred to in Justice Janane's decision, which had followed a contested application that had been heard on the papers. The plaintiffs had given the court evidence, and this is a matter of the record of the proceeding as well, that the defendants had participated in the conduct of the application that was heard on the papers, and therefore the evidence that His Honor had referred to in his judgment, which was the evidence of the termination of the proceedings, was evidence that had been served on the defendants. Your Honor did not make any assertions or determinations that indicated that Your Honor had failed to accept the evidence of the plaintiffs. Nevertheless, Your Honor refused to either make the orders in accordance with the presumption that the proceedings had been terminated, or, as the plaintiffs had suggested, inquire more robustly of the defendant's counsel, the basis upon which they sought to refute the evidence that the plaintiffs had provided to the court regarding the service of the relevant evidentiary material on the defendants. And in refusing to apply what the plaintiffs submitted, was the law that the court determined issues of fact for itself. The reasons that Your Honor gave were that a short delay in the determination of the matter would not cause any prejudice. Notably, Your Honor had not given the plaintiffs an opportunity to be heard in the matter, and because of the peculiarity of these disputes between the parties, Your Honor, we submit, firstly, could not have known the intricacies of the prejudices involved. And, secondly, we say that in a proceeding where the plaintiffs have filed extensive evidence of the defendant's improper attempts to collude with or influence officers of this court, we say that it was imprudent, and it was tactless of Your Honor to, then, make orders on a presumption that the assertions from the bar table made by the defendant's counsel, which our evidence suggested were misleading, were more reliable than the sworn evidence that the plaintiffs had filed. As a matter of fact, the reason why the defendants had sought to delay the reinstitution of the proceeding, and we note here that they're now seeking to apply for orders, by accepting that the proceeding could be reinstated lawfully. They had initially resisted the reinstatement of the proceeding. In fact, they never actually consented to the reinstatement of the proceeding. I have shared emails this afternoon on which I said I would rely. And the email correspondence confirms that, on the 1st of April, the last correspondence from the LSB's solicitors was that Your Honor could not automatically reinstate the proceeding, and that the matter had to be first listed and decided by a judge. I responded to that email and noted that the orders operated on the presumption that the LSB could not, in good faith, take any objection, and therefore their consent was presumed under the law. So Your Honor did not provide any reasons for why the particular orders were made, and I do not know of any other legal rationale which could form the basis for the reinstatement of this proceeding. So my understanding is that the proceeding has been reinstated because Your Honor effectively ruled that LSB could not, at law, refuse consent to the orders that were made. And then I had advised the LSB, at the time via response on the first paper, that if they sought to appeal that matter, that was the only way they could agitate the matter. They have not done so, and they have now accepted Your Honor's, my interpretation of Your Honor's orders. And they haven't provided any alternative basis upon which they accepted the reinstatement of this proceeding. So it's the plaintiff's contention that the reason why the defendants had improperly sought to delay the reinstatement of the proceeding was that within approximately 2 weeks of the hearing there was a hearing of the defendant's purported creditor's petition listed in the federal court, and they wanted to prevent the plaintiffs from relying on the ground that they had counterclaims against them that were being considered by the Supreme Court as a basis to oppose that creditor's petition. That was the prejudice that the plaintiffs were facing. It was a serious prejudice. But more importantly, when the judicial officers of the state automatically accept the position of the executive, it brings the administration of justice into disrepute. So was said in Strickland v. Director of Public Prosecutions 100th. The citations for the proceeding is or the judgment is, 2018, HCA 53. Yong Jun Shin v. Minister for Immigration and Ethnic Affairs, 199775 FCR 155, also affirms that principle. The second authority has been cited by the Attorney General of the Commonwealth as the basis upon which the courts should deal with matters concerning model litigants. There is also the Hickman principle, which is the principle stated in the Queen v. Hickman 1945 HCA 53, and it basically states that for the executive to legitimately hold a position or make a decision, there are three aspects that must be satisfied. Firstly, the actions must be taken in good faith. Secondly, they must be taken within the scope of their lawful authority. In their case, we say it was the LSB's case. It was the uniform law and the objectives of the legislation that are stipulated in the indistinct instrument. And then the third aspect of a lawful decision is that it complies with the common law rights of the bodies that may be adversely affected by it, and the constitutional limits that apply. So the principle of legality and proportionality being, important aspects of the constitutional limits to the order. So we say that the manner in which Your Honour failed to consider the potential impact of Her Honour's decisions on the rights of the plaintiffs was incompatible with Your Honour's obligations pursuant to S32 of the Charter of Rights and Responsibilities. And it also contravened the plaintiff's rights pursuant to S24, which is the right to due process in proceedings, and also equal recognition before the law and other associated provisions. I'm going to conclude with quoting one paragraph from the authority that I previously cited, QIFM. This is paragraph. These are paragraphs 47 to 49 of the judgment of Chief Justice Kiefel and Justice Gegler as they were at the time. Being fair-minded, the observer is neither complacent nor unduly sensitive or suspicious, yet the observer is cognizant of human frailty and is all too aware of the reality that the judge is human. The observer understands that information as well as attitudes consciously and conscientiously discarded might still sometimes have a subconscious effect on even the most professional decision-making. Being lay, the observer is not to be assumed to have a detailed knowledge of the law or of the character or ability of a particular judge. Though the observer may be taken to understand that the judge, by reason of profession, training and experience and fidelity to the judicial oath or affirmation, will have a greater capacity than most to discard the irrelevant, the immaterial, and the prejudicial, and to discharge the judicial function uninfluenced by past professional relationships. The public perception of the judiciary is not advanced by attributing to the observer a knowledge of the law and an awareness of the judicial process that ordinary experience suggests not to be the case. This indicates that the observer will see the person who is currently a judge as the person who was formerly an advocate, and may be less inclined to disassociate the advocate from the cause advanced. This is not strictly relevant. It was relevant in that particular authority, so I'm not going to complete this part of the paragraph. Indistinct words, last part, which is, nor is the observer so abstracted and dispassionate as to be insensitive to the impression that the circumstances in issue might reasonably create in the mind of the actual party who is asserting an apprehension of bias. The observer can be taken to appreciate that a party, especially an individual, and again, not relevant, especially a non-citizen facing deportation. It's relevant, by comparison, in the sense that we feel that we have been mistreated by agencies that are responsible for enforcing the rule of law. And the same agencies are now perverting the course of justice and preventing, and seeking to prevent the plaintiffs from enforcing accountability measures against their officers. And we say that the reasonable observer would be sensitive to Your Honours, the disparity with which Your Honour treated the two parties, and the fact that I was forcibly removed for asking Your Honour why Your Honour would not accept the evidence that the plaintiffs had provided to the court. I was simply seeking reasons which is my right to seek. And in this respect, I also add that following the hearing, once all parties had accepted that the proceedings had been reinstated, when an extension to the filing that line was sought, Your Honour did not respond to the repeated requests by the plaintiffs for the extension of the deadlines which, by the way, was sought by consent from all parties. And the court did not provide confirmation of the extension of the deadline until I believe it was the 21st or the 22nd of May, which was either on the day or the following day, after the Legal Services Board had commenced a proceeding in the federal court, the purported purpose of which was to prevent us from adducing evidence in this proceeding regarding the allegations that the plaintiffs had sought to introduce in this proceeding about their officers, to demonstrate that the evidence that the plaintiffs had already shared with the registry and the court comprised evidence that a senior officer of the Legal Services Board, Ms. Joanne Jenkins, had previously worked as an unregistered sex worker, and,
Your Honour, I'm instructed to object to this. There's a suppression order in place.
There is no suppression order,
I fail to see the relevance, Mr. Kuxal.
and I am getting to the relevance of this.
Mr. Kuxal.
You have to hear me.
Mr. Kuxal, I've heard long submissions already. I've just heard an objection.
I am. As I've said, I'm concluding. This is the last part. I need 10 minutes to conclude what I'm saying, but I am permitted by law to raise the matters that I'm raising. So on. I will refer to the email that I had sent to the court. This was the email. When was the hearing? On the... Okay, so on the 16th of... On or about the 15th or 16th of May, the plaintiffs had forwarded communication that they had filed in the federal court, and the plaintiffs indicated that they would also file the same evidence in these proceedings. And the evidence demonstrated that the Legal Services Board had been improperly seeking to prevent multiple lawyers from filing evidence in relation to the criminal conduct of Mr. Howard Bowles, a senior manager at the Legal Services Board.
Objection, Your Honor. There's a suppression order in place.
Mr. Kuxal.
Yes, can you please?
Mr. Kuxal, I am warning you to keep your submissions strictly to your application for my recusal.
They are strictly limited to...
I am telling you that matters regarding a federal court proceeding.
I'm not talking about a federal court proceeding. I'm talking about correspondence that was sent in this proceeding.
I have not seen the correspondence. I don't know what you're talking about.
Well, Your Honor, it is a matter of the court record. Your Honor can look it up. I will provide the...
Mr. Kuxal, move on please. Move on.
This is my submission. I will make my submission, unless...
Mr. Kuxal, I am warning you to keep your submissions relevant to the point of recusal.
They are relevant to the thing. You need to hear me before.
Mr. Kuxal.
Your Honor, are you determining relevance of the evidence before hearing what the evidence is?
I have just heard it, and I have just indicated.
No, you haven't. I haven't completed. S-192 of the Evidence Act sets out how the court needs to exercise the discretion in relation to various exclusionary measures. There is no application that is made to exclude any evidence in this proceeding. I can give evidence that there is no suppression order that applies. In fact, I refer the court to the judgment of the federal court.
Mr. Kuxal, I am not reading a judgment of the federal court. It is quite simply not relevant to the directions that I am required to make on the application.
I am clarifying what the relevance is. It is directly relevant, and it has prejudiced us in the lodgment of documents. On the 16th of May, we had indicated to the court, by providing the court with this court and Your Honor's chambers. On or about the 16th of May, we have provided Your Honor's chambers with an outline of the affidavit that, with an outline of the evidence that would be adduced to the affidavit regarding the corruption and criminal conduct of various officials of the Legal Services Board, including Mr. Joanne Jenkins and Mr. Howard Bowles. And the fact that the Legal Services Commissioner's condonement of that conduct was a basis for the court to draw inferences about the affidavits, the manner in which the Commissioner was conducting their affairs, and taking adverse actions against various people that they were taking adverse actions against. We had sought an extension to the deadline, so that evidence could be filed. We repeatedly inquired with the court about the extension.
Your Honor, I don't mean to interject, but I've been shown an order here, which is a suppression order. It's an order of Justice Meagher of the Federal Court, dated the 21st of May. Allegations are made in that particular proceeding, and this order specifically says, until the hearing and determination of a certain interlocutory application or further order.
Give me the citation for the proceeding.
Publication of these particular allegations and any documents referred to in Order 3 is prohibited.
Sorry, Your Honor. Firstly, he's interrupted.
Mr. Kuxal, I am going to ask you to sit down and stop talking, please. I have heard your submissions.
No, Your Honor. I want to address what Mr. Hogan has said. Okay? He has made an allegation that I have breached a suppression order. It is a very serious allegation.
I object to that. I said that I was concerned based on the instructions that I had received. There is a difference.
Okay. So he's implying that I may be breaching...
Mr. Kuxal, can you...
Your Honor, I have a right to address that. He has made allegations that affect my reputation, and...
Mr. Kuxal, he has done no such thing.
Okay? Your Honor, I just want to address the specific point from the judgment of Justice Meagher that accompanied those orders, okay? So, this matter, this is a judgment, a full judgment. There can be no impropriety in referring to the judgment. So I'm just getting the citation. So this is LSB versus Kuxal, Victoria Legal Services Board v. Kuxal, 2025, FCA 558. And I refer to paragraphs. Okay, so paragraph 33 of that judgment. Mr. Kuxal asserted that this court did not have jurisdiction to hear the matter being, so the Legal Services Board had made an application in the federal court that that court make orders that prevent me and my associates from adducing evidence in relation to the matters that I've previously said out loud in this hearing. So, adducing evidence of those matters in proceedings before the Supreme Court. I submitted to Her Honor that the federal court did not have jurisdiction to make such orders, and this is what Her Honor said at paragraph 33. Mr. Cook's Honor asserted that this court did not have jurisdiction to hear the matter. He pointed to SS 39B, 55A, 55B, 55D, 64, and 78 of the Judiciary Act in that regard, and relied upon Thompson Australian Holdings, Podiwai Limited v. Trade Practices Commission, and APLA Limited and Ors v. Legal Services Commissioner of New South Wales and Ainur. He submitted correctly that the federal court had no jurisdiction with respect to the Supreme Court of Victoria. According to Mr. Kuxel's submissions, the dissemination of the material, the subject of the application, had already occurred. So on and so forth. That is not relevant anymore, but Her Honor precisely noted that the Supreme Court of Victoria was responsible for maintaining the integrity of its own processes, and the federal court had no jurisdiction to make any orders that would affect the way in which the proceedings were conducted in this court. And no orders have been made that affect the jurisdiction of this court to regulate its own affairs. I say that the submission was improper by Mr. Hogan because no person familiar with the law could accept at face value that such an order could have been made, let alone a legal practitioner who is a member of the bar. It is an extraordinary matter to accept at face value, and he could not have simply seen something and become a mouthpiece for his client without conducting his due diligence that he was acting in fidelity to his obligations under the law. Anyway, Your Honor, so the point that I'm trying to make is that, again, this is an application on the apprehension of bias. No allegations of fact are made against Your Honor. But what they're saying is that we sought leave to file evidence in this proceeding, repeatedly. That leave was repeatedly denied until the 21st of May. And the one problem that those orders potentially cause, in the view of the second plaintiff, not in my view, is that because the orders, by the way, these are interlocutory orders this was an interim order which was made because the application could not be heard that day. We had sought an adjournment because the application had been brought on very late, and because we had sought an adjournment, the court sufficiently narrowed down the scope of the orders that the LSB was seeking. They had basically sought to prevent us from publishing any allegations against any of their employees, and the court basically said that we cannot freely publish a specific allegation against, well, that involves two of the employees, Mr. Howard Bowles and Ms. Joanne Jenkins.
Mr. Kuxel, I warned you.
I've already said this, Your Honor.
I want you to stop now. I've heard your submissions.
No, I'm not done, and I'm not raising this matter again. Your Honor, I've only asked for 10 minutes. I'm being constantly interrupted. I would have been finished by now.
Mr. Kuxel, it is now 3:10. You have been going on with these submissions for at least 45 minutes.
I need 2 minutes to complete what I'm saying.
It's been a long submission.
Your Honor, the manner in which Your Honor is anxiously interrupting
I ask you to
gives an apprehension that Your Honor is improperly concerned about the interests of the defendants in a manner that Your Honor may not lawfully.
Mr. Kuxel, I'm going to give you 1 more minute.
That's not acceptable, Your Honor.
Well,
No, I need 2 minutes.
that is my decision.
There is no basis upon which Your Honor would...
Mr. Kuxel, you have 1 minute.
I need 2 minutes.
You have 1 minute to complete your submissions.
Your Honor, I have asked for 2 minutes. There is no basis upon which...
It is now 11 minutes past 3. I'm going to give you until 12 minutes past 3, and I ask you to complete your submissions.
Again, I will not submit to that decision without reasons, and I will complete what I'm saying. What I was saying is that the one way in which the second plaintiff is of the view the orders may affect the conduct of the plaintiffs in relation to this proceeding is that the service of those of the evidentiary material, because it is not strictly court process or a process involving the court, the second plaintiff was concerned that in serving that material on the LSB's solicitors and the officers of the board, it may be argued, even if improperly, that a breach of the order had been permitted, and we should wait until the hearing is concluded. There was a brief interruption in the resumption of the matter because the judge hearing the matter recused herself from further involvement in the matter and allocated the matter to a different judge, who then again recused themselves because they had previously made orders in other proceedings involving the parties. So they recused themselves on an application by the plaintiffs in this matter. And because of the repetitive, successful recusal applications, the matter had to be relisted, and it is the judge currently presiding over the matter, has tentatively listed the matter for the 30th of June and the 1st of July in that proceeding. Henning Enzig. So my view was that any service of documents lodged in the Supreme Court is basically an exercise related to the proceeding, and therefore not simply publication in the general sense of the word. But because of the second plaintiff's anxiety over the possibility that the Legal Services Board would then abuse the opportunity to commence further frivolous proceedings, we could not lodge the evidence and the applications that would have been supported by that evidence in this proceeding, and that was simply because Your Honor waited from when we had sought the extension. And this was over a period of 2 weeks. For approximately 2 weeks, we repeatedly wrote to Your Honor's chambers, seeking an extension by consent.
Mr. Kuksal, it is now 3:15.
And I'm concluding.
I'm asking you to conclude. I'm asking you to conclude. No, I would like to rule on your recusal application, so please have a seat.
Okay. And then I will address the...
Mr. Kuksal, please sit down.
Yeah, I'm just clarifying that I have to address the substance of the...
Mr. Kuksal, I run the proceedings here, not you. Now sit down, please. Mr. Hogan, what do you say about the recusal application?
I don't think we have anything to say. I've heard nothing that relates to our case.
Thank you.
It's simply a matter for the court.
Mr. Imrie.
Likewise, Your Honor.
Thank you. The recusal application by the applicants...
Sorry, Your Honor. You didn't ask Ms. Shu. She's a party to this matter.
I don't need to hear from Mesik Su. I don't need to hear from you. Thank you, Mesik Su. The recusal application is refused. The submissions made by Mr. Kuksal do not articulate a basis for a recusal, nor have they identified any unfairness that would warrant me to recuse myself, including based on a previous hearing in March 2025. The plaintiffs have been given adequate opportunity to be heard. Despite the long submissions made by Mr. Kuksal, I consider that the plaintiffs have been given adequate opportunity to make submissions and provide material to the court. While I have been in a position of having to discourage excessive interventions, this does not constitute a bias. There has been no unfairness identified in the hearings that I have presided over. I fail to say that there has been any breach of human rights or any failure to exercise the court's discretion in accordance with the rules. Mr. Kuksal, I'll now hear you on the proposed orders provided by the defendants in all 3 proceedings, please.
Okay. I just want to point out that there was a disparity in Your Honor's treatment of Ms. Shu, in that Your Honor heard from everyone.
Thank you, Mr. Kuksal.
Let me just complete this. It doesn't take too long.
Mr. Kuksal, I've asked you to complete your submissions with respect to the proposed orders.
Yes. And before that, I was just saying that Your Honor asked every other party in the proceeding to express their view about the recusal application, and specifically excluded Ms. Shu, despite the fact that I pointed out that she was being excluded. I plans.
Thank you. Thank you for pointing that out, Mr. Kuksal. Please continue.
Now, Your Honor, would Your Honor please call the other 2 matters at the same time so they...
Mr. Kuksal, you've just made a recusal application with respect to 3 proceedings. Groka.
I just want your leave to...
So why don't we just assume that the orders we're making today are with respect to the 3 proceedings, as Mr. Imrie pointed out at the beginning of the hearing. So could you make your submissions about those, please?
I'm happy to do that, but I don't think that...
Thank you, Mr. Kuksal.
That's what he had done. So if I'm addressing all 3 proceedings together, then the first matter I would like to address the court about is that on the 4th of January 2023, Justice Osborne had made orders in the proceeding ending in 05407, and I'm just going to bring up the orders that His Honor had made. Okay. So the orders state that the court orders that the first order, the further hearing of the originating motion and the summons filed by the plaintiffs on the 23rd of December 2022 and the 30th of December 2022 respectively, His Honor refers to those documents as the court documents, are adjourned for further directions before a judicial registrar or associate judge of this court on a date to be fixed not before the 3rd of February 2023. The plaintiffs will provide the court documents, their proposed orders for the hearing, on the 4th of January 2023, which were received by the court at 4:58 p.m. on the 3rd of January 2023, and this order to the Victorian Legal Services Board and Commissioner, Victoria Police, Holding Redlick, and the IBAC, for the purposes of those 4 parties to consider whether they wish to be joined in this proceeding, given their involvement in related proceedings and/or the potential for them to be affected by orders made in this proceeding. Upon the plaintiffs receiving a hearing date for the directions referred to in paragraph 1 of these orders, the plaintiffs shall give notice to the parties listed in paragraph 2 of these orders of such hearing date as soon as is reasonably practicable, there be liberty to apply, costs reserved. Now, Your Honor, on the 4th of August 2023, on or about, the State of Victoria had brought and had sought leave from Justice Janane to bring an application for these summons to be set aside. Justice Janane refused to give them leave for such an application to be made, and His Honor confirmed that these summons are extant in these proceedings. And the next step in the proceeding would be the listing of the hearing in accordance with the summons.
I fail to see the relevance with today's directions, Mr. Kuksal. So if you could just...
Yes, the relevance is that the orders that there is a pending hearing of those summons in this matter, that Justice Osborne has ordered Your Honor to list. Those orders are extant. What the defendants are seeking to do is get Your Honor to effectively contravene those orders and first have a summary dismissal application listed, which they cannot request, because the summons seeking such an order have not been filed before the court. And again, I refer to Rule 46.05. There are no summons that they have lodged in accordance with the rules. A judge has made orders that Your Honor list the hearing of the matter in accordance with the summons that we had filed on the 30th of December 2022. This matter was confirmed again by Judicial Registrar Keith. If Your Honor could please confirm the last order that was made in this proceeding. Okay. I'm not sure what Your Honor's hesitation is in confirming it, but I note that Ms. Zhu has provided me with a copy of the orders. These were orders made by Judicial Registrar Keith on the 31st of January 2024. And they state that the court orders that the directions hearing listed be adjourned to the 14th of February. It's the 14th of February that I need the orders from. So on the 14th of February, Your Honor, could you please confirm if the court has a record of the orders that were made on the 14th of February in this proceeding? I mean, I can look it up, but it'll just take a...
I'm really unclear about the point that's being made here. Mr. Hogan, are you able to assist the court, please?
No, Your Honor. The point is that there are extant orders and summons that direct Your Honor as to the further conduct of the proceeding. I'm just going to go to Redcrest and look up the orders that were made.
I understand they're completely separate proceedings. I have no understanding.
You're not involved in that proceeding?
Of how that proceeding could impact upon this one. I can't add anything further, unfortunately.
Your Honor, you asked me to address you in relation to all three proceedings at the same time. I said, I will start with addressing you about 05407.
And I am not understanding your submission. I have Registrar Keith's order here of the 31st of January.
And then the 14th of February? Does Your Honor have the orders from the 14th of February as well?
Yes.
I'd be grateful if Your Honor could confirm what those orders are.
Why don't you make your submission, please, Mr. Kuksal?
Well, Your Honor, I do not know why you wouldn't help a self-represented litigant, and with just the orders on file, but I find those on Redcrest now. So these are the orders. By other matters, by originating motion filed.
Don't need you to read it. Thank you, Mr. Kuksal. Just tell me the point that you're trying to make.
The proceeding. The orders that were made were this. The proceeding, including the balance of the plaintiff's summons filed the 30th of December 2022, and the foreshadowed application by the second defendant, be referred to a judge for consideration of the consequences of the judgment and orders of Janane J. in proceeding SECI 202-204808. Now, for context, at the time, the proceedings in the magistrate's court had not come to an end, and what had been submitted to Judicial Registrar Keith was that in light of Janane J.'s orders or judgment, where His Honor said that the proceedings in the Supreme Court should wait until the conclusion of the proceedings in the magistrate's court, the summons that were pending determination that Justice Osborne had partly heard, they should be, temporarily. The listing of a hearing pursuant to those summons should be temporarily delayed until the magistrate's court matter has concluded. The plaintiffs did not say that that was the right course of action, but they conceded that such was the effect of Justice Janane's orders, and until they were set aside by the appellate court, they should be in operation. So what Judicial Registrar Keith did at the time was that His Honor held that he did not have the authority to suspend the effect of the orders of Justice Osborne, so the matter should be listed before a judge to consider whether the orders of Justice Osborne should be temporarily stayed, to give effect to the principles that Justice Janane had set out in the related proceeding. That matter is no longer relevant now. So effectively what the court must do is list the balance of the summons for a determination as per the orders made by Justice Osborne on the 4th of January, which were affirmed by Judicial Registrar Keith, as is clear from the order. And we note that those orders only affect the state of Victoria from the parties that are here. Your Honor was asking Mr. Hogan. His clients are not even parties to that proceeding, so it could not have helped Your Honor in any event.
All right. Thank you, Mr. Kuksal. You can sit down now.
So that was just one proceeding.
Yes, I understand. I'm going to address that now. So I'm going to make orders in the proceeding ending in 05407. I'll order that any further interlocutory application by a party to the proceeding is be made by summons with supporting affidavit. Such application to be made returnable before a judge of the court on a date not before the 7th of August, 2025, with a duration of 1 day. If the defendants propose to make any further application, it must file and serve any written outline of submissions, along with any further affidavit, on or before the 3rd of July, 2025. Plaintiffs can file and serve any written outline of submissions, along with any affidavits in respect of any application filed by the defendants on or before the 24th of July, 2025. I'll reserve costs and give parties liberty to apply.
So, Your Honor, what about the pending summons that Justice Osborne had ordered be listed for here?
That will go before the judge. Those matters can be dealt with by the trial judge.
Can Your Honor also include that in Your Honors?
I'm just going to make this order today. If there are extant orders, they'll be dealt with by the trial judge.
But could Your Honor include that in other matters, or whatever?
Thank you, Mr. Kuksal. I don't require any further assistance from you with respect to 5407. Is there anything else that is required? Thank you. All right. I will now hear you about 0183 and 4808.
Okay. So the first matter that I wish to identify to the court is that I have not seen any of the proposed orders. As I've said, I can give evidence in that respect as well, on oath, that I was in hearing this morning, and I have not had an opportunity to go through my emails, and I have not seen the orders. But I understand from what was said that, and also previously foreshadowed matters, that the plaintiffs are, in effect, the defendants are, in effect, seeking a summary dismissal application. And the first thing I have to say in that respect is that, of course, Your Honor cannot stop them from filing such an application or having an application of that sort listed to be heard. But it will necessarily be an abuse of the court process, because Justice Janane has already dismissed those applications. The basis upon which His Honor had temporarily stayed the proceedings was that His Honor had rejected the summary dismissal applications by the defendants in these proceedings. And I will give the citation for the judgments that His Honor had made. So the most prominent one is the judgment that was given on the 20th of December, 2023. So that's 2023 VSC 625. But there's also another judgment that His Honor had, 2023 VSC 438. So His Honor has already dismissed summary dismissal applications. They had effectively exhausted all the bases upon which those applications could be argued. The grounds were the same. I cannot see how it can succeed. But I accept that if they want to make an application, they have a right to be heard about that, in effect. And, in any event, a judicial registrar should not stop them from having such an application listed. We note, though, that this will necessarily lead to delays in the determination of matters, because whatever documents we did not lodge for, or could not lodge, rather, for the proper advancement of the matters, we will lodge in response to the summary dismissal applications. We can also seek subpoenas in response to the summary dismissal applications. All that will do is delay the matter, and we will seek appropriate orders in that respect. But what we wish to do is have 2 applications listed, or 2 orders made by the court in respect of those 2 matters. And the second order should also apply to the proceeding 05407, because Your Honor did not let me raise this matter, which I had forgotten to raise earlier. By the time I remembered it, Your Honor asked me to sit down. We want the applications to be heard by a judge from a different jurisdiction rather than the Supreme Court of Victoria, or we want an application to be heard regarding the appropriateness of a judge, an interstate judge, to preside over the hearing of the applications in the 3 proceedings. We note that the federal court has accepted that application, and our matters in the federal court are being heard by a judge from Queensland because of the allegations we made about the Legal Services Board's improper interference and influence over the offices of the local registry and their association with officers, some officers, locally. Such an application should not be made without evidence, and I'm not going to raise matters like that without evidence being filed. So we seek directions from Your Honor for the filing of material, so a judge may hear our application that the matters be adjudicated by an interstate judge. That's one order that we seek, and then the other order that we seek this order in all three proceedings. I'm not presuming to speak on behalf of Ms. Xu exhaustively, so Your Honor should hear from her as well. But what I'm saying, she agrees with, because I have discussed with her. The second matter that we seek orders in respect of is leave to file, any applications, including subpoena applications, that we wish to file. And in all three proceedings, basically, and we need at least 4 weeks to file the material that we intend to file in support of our applications.
Thank you, Mr. Kuksal. Ms. Xu, is there anything you wanted to add to the request for those orders?
Nothing, apart from the stress that I want 4 weeks to respond. It's because that the Legal Services Board has written to the court and said that because of their proceedings against us in the federal court, so, the court should wait for them. And we have suffered some prejudice from waiting for them, and now we're not in a great position to respond within 2 weeks. I think that is too short, so I just stress that 4 weeks is at least the least period of time.
Because of the number of...
Yeah, so now they have filed many other proceedings and interlocutory applications in the federal court, so we have to deal with those. So again, 4 weeks will be the least time that I require. Thank you.
Thank you, Ms. Xu. In all three orders, I'll give the parties liberty to apply, so further applications can be made in all proceeding. In proceeding number 04808, I'll order that the first defendant file and serve any written submissions in support of their application filed by summons on the 5th of June, limited to 15A 4 pages. And the third defendant file and serve written submissions in support of their application filed by summons on the 12th of June, limited to 15A 4 pages by Friday, the 25th of July, 2025. The plaintiffs file and serve written submissions in response, limited to 15A 4 pages, and any affidavit of evidence upon which they rely by 4 p.m. Friday. The 8th of August 2025, the first defendant file and serve written submissions limited to 10A 4 pages, and any affidavit evidence in reply. And the third defendant file and serve reply submissions limited to 10A 4 pages, and any affidavit evidence in reply. The hearing of the defendant's applications be listed on a date not before the 11th of August 2025. Liberty to apply, and I'll reserve costs. In the proceeding 00183, by 4 p.m. Friday the 4th of July 2025, the 1st to 9th, 11th, and 14th defendants file and serve written submissions in support of their application filed by summons on the 5th of June 2025, limited to 15A 4 pages. The 12th and 13th defendants file and serve written submissions in support of their application filed by summons on the 12th of June 2025, limited to 15A 4 pages. By 4 p.m. on Friday, the 25th of July 2025, the plaintiff file and serve written submissions in response, limited to 15A 4 pages, and any affidavit evidence on which they rely by 4 p.m. On Friday, the 8th of August 2025, the 1st to 9th, 11th, and 14th defendants file and serve reply submissions limited to 10A 4 pages, and any affidavit evidence in reply. And the 12th and 13th defendants file and serve reply submissions limited to 10A 4 pages, and any affidavit evidence in reply. The hearing of the defendant's application be listed on a date not before the 11th of August. I will reserve costs and give liberty to apply. Is there anything further? Space?
Nothing from me, Your Honor.
No, thank you, Your Honor.
Mr. Kuksal, Ms. Xu?
So, Your Honor, I presume that Your Honor will note the applications that we foreshadowed regarding the matter being heard by...
I've given the parties liberty to apply, Mr. Kuksal.
But can Your Honor note in the other matters that we had sought these orders?
It will be reflected in the transcript, Mr. Kuksal. If there's nothing further, I'll adjourn the court. Thank you for your attendance today.